Hi there, my name is Grant Abbott. I'm a councillor from out in Musgrave Harbour Newfoundland who has been evicted from their seat using collusion and targeted policies and procedures that only I would most specifically be directly affected. Come out and check out our beautiful sandy beaches on your next summer vacation. Our coast has Florida's beaches out in the North Atlantic. I'll be reading from the screen due to my language processing disability, covert stuttering and aphasia. In our last council meeting, the councillors unanimously agreed to schedule a special meeting to discuss policies and procedures, but this is yet to happen. Tomorrow will be our second meeting since my sit-in, including and the first meeting since the first official meeting since the last scheduled meeting. And tomorrow will be the second meeting since my sit-in and the first meeting officially since the last scheduled meeting, including the substitute meeting to replace the regular meeting. I had found that standing on a point of order was in the rules of procedure for the town, as well as Robert's Rule of Order. And now that it's been found, the town clerk claims that it's not part of the document of the rules of procedure for the town, and that if it were, she was going to go and ask the council at the next meeting to rescind those conditions. It's interesting that we can consider to eliminate the exception to the rule to discuss a serious issue, but we can't discuss the serious issue as urgently as removing the exception to the rule. I've asked to see the official rules of procedure at least 5 times since this was said, as well as the minutes of where the words regarding the rules of procedure and Robert's Rule of Order, standing on a point of order, were removed. I've yet to be acknowledged on this question or be provided the information of which has been asked. I did my best in this document to correct the tense and turn this document into a presentation. Let's see how long it'll take and how much consideration was needed to see all my points through responsibly. Let's start the clock. My elected seat had been vacated after my fellow councillors leveraged and weaponized the Municipalities Act using remote attendance policy with the stipulation that one could not be unvaccinated as a reason they could not attend council meetings in person, and they required remote attendance accommodations to have vaccination in order to get on Google Meet or telephone. On April 27th, 2023, I had called a point of order on a policy that had been implemented in my absence. The policies, I believe, to be a direct measure taken against me to prevent accountability and transparency. I had provided my items to be put on the agenda, and the town was well aware and forewarned of my concerns and intentions, even as to what I would do if the meeting were called to an end. I had edited my submission to council regarding the illegal policies and procedures, and I had insisted that we work it out urgently. This document I'll post, and the accompanying video represents my position and what had been said and what I had said with the modifications to make this flow a little better. The town had much advice and many opportunities to consider my concerns privately. They had been offered mediation by Human Rights, but it had been declined. As well, we had sent back and forth many settlements that did not solve any problems at hand. One of the settlements was for $5,000 to cover expenses, as well as $5,000 to be put towards Chromebooks in order for it to allow us to communicate better and to have a private way of doing business as per the Privacy Act. No one wanted to talk any of these things out through the settlements, and no one wanted to say any of the facts out loud. Right now, we're still in the dark as to what has got us here and how we're going to get out of it. At the time of the meeting, the clerk had photocopied this original document of which I'm reading right now and had provided it to everybody before the meeting. So they're all fully aware of my claims, and they should be acting on it right now. It's almost as though they think I'm going to go away still. The document was submitted before the meeting began and accepted as supporting documents for the evening. That means that it's officially on file. Generally, a point of order must be raised at the time the rules are broken, or else it would be too late. For example, if a motion was made and a discussion began on it, it would be too late to raise a point of order on that motion if it was not seconded. And if such a motion was adopted without a second, it remains valid, and not having a second becomes irrelevant, and there's no need to discuss it any further. Exceptions to the rule is that this is called a point of order, and it must be raised at the time of validation it must be raised at the time of violation, to include that the point of order may be raised at any time a motion was adopted in violation of the bylaws or applicable law, in conflict with the previously adopted motion, unless adopted by the vote to rescind it, or in violation of the fundamental principle of parliamentary law. Take note here that parliamentary law is included in these definitions during training for a councillor, in which all other councillors are supposedly have already taken right now. It clearly said that parliamentary procedure is what the town leans on as rules of procedure in absence of any other documents. This being said, if I look up the parliamentary procedure, it does say that Robert's Rule of Order and standing on point of order is a real thing. And as well, it shows it's inside the rules of procedure for the town. And also, further to that, it's just a thing that's normal for these sorts of boards to do. If something is illegal, you need to stand up and say something about it. In this case, I was in the process of recording, and in order for me to stand on a point of order, I would need to call it out at that moment of which it was called upon me. So as soon as the mayor said, "Is anybody recording this meeting?" I would say, yes, I'd like to stand on a point of order, and at such point I need to go into the rest of standing on a point of order in order for it to do my job as per the rules. The ruling of the chair may be appealed to the assembly in most cases. So that means I guess I can say to the group, even though if the chair says no, I can look at everybody else and say we need to deal with this, and a majority vote against the chair's ruling is required to overturn it. So the group of the other councillors could listen to what I had to say and overturn it if they so desire. This is just how these sort of debates work. Everything that happens in these meetings is in public domain. There's no legal pathway to prevent councillors or even attendees from recording these meetings. As an example of this, during COVID, we were told by the government to broadcast meetings when public health restrictions prevented attendance. This was because it's a right for anyone who's interested to hear everything without copyright, editing, or censorship. We, as the council, had agreed unanimously to get a lawyer to see if the town was permitted to enforce policies that I called out as being illegal when I was still a councillor. But this action was still not taken, and it was apparently assumed that I wouldn't proceed legally, despite my many warnings to the contrary that I would be proceeding. And when the town did finally seek legal counsel, they were told not to proceed against me, but they ignored this expert advice. Today, not only do these legal policies and procedures still stand, but new ones have been created, and the old ones have been strengthened and reinforced. Since writing this, the town has taken my advice and rescinded the vaccination policy, but I'm not clear in terms of the extent of the rescind of the policy. My intention was to remove all policies as it pertains to vaccinations due to them being discriminatory, as much as prohibiting people with red hair from running politics is also discriminatory. The council is creating policy that stands in direct opposition to the law. The Criminal Court of Canada, as well as the Supreme Court of Canada, are clear with their legislation and rulings on the matter. Nothing the town does can supersede the laws of the provincial and the federal jurisdiction. Before I read the Criminal Code of Canada, I must point out that there's a precedent in legislation in the province of Quebec to help us understand what exactly we should do here. It's called Bill 495, and that summarizes this right for us, and it can be transmuted to us through federal, localized, provincial, and common law. Bill 495 is an act to authorize the recording of sound and images during the public setting of municipal council or the public meetings of a council in a metropolitan community. Explanatory notes. The bill reaffirms that the municipal council sittings and metropolitan community council meetings are legally open to the public. In addition, the bill specifically says that a person may not be prevented from attending or sitting or meeting on the grounds that the person is not a resident of the territory or of the municipality or of the metropolitan community. Lastly, the bill expressly authorizes the recording of sound and images by a person attending the municipal council or the council of a metropolitan community. I would call for us to implement a policy like this and repeal legally conflicting policy. Global News also covered this, and they referenced the Criminal Code of Canada in doing so. They said Section 184 of the Criminal Code states that recording private conversations is legal as long as one of the parties involved in the call consents to the recording. It's called the one-party consent exception. This means that the second person involved in the call does not have to be informed that the call is being recorded. If several people are involved in the phone call, it's still legal for one of them to be recorded without informing the others. Section 184 of the Criminal Code says, interception 184.1. Every person who, by means of any electromagnetic, acoustic, mechanical, or other device, knowingly intercepts a private communication is guilty of a. An indictable offense and liable to imprisonment for a term of not more than 5 years, or an offense punishable by summary conviction. This suggests that only private communication is covered as being illegal. The saving provision is what is covered in this situation and brings this into more light. Subsection 2.1 says does not apply to a person who has consent to intercept, express, or implied of the originator of the private communication or of the person intended by the originator thereof to receive it. B. A person who intercepts a private communication in accordance with authorization or pursuant to section 184.4, or any person who in good faith aids in any way any other person who is aiding a person believing on a reasonable grounds is acting with the authorization or pursuant to section 184. The fact that it says that the person believes on a reasonable ground that is acting within authorization or pursuant to section 184.4, that suggests that this particular document says that you have permission if you have expressed or implied permission to intercept or received the information, if you are the person intended by the originator to receive it. This suggests that due to this being a public meeting, that I and a councillor and the public are intended recipients of the communication, and that I am acting in good faith in recording this communication, and that I can record this meeting. For the town to create policy that says it can be the sole recorder of, the copywriter of, can edit, censor, and control use of said recordings of a public meeting is firstly illegal, and secondly a clear attempt to prevent the transparency I provided by recording and posting the contents of the meetings to begin with. To create policy that is firstly in direct conflict with the law, but secondly aimed directly at a duly elected member of the council is reprehensible. The town and elected members here before us know full well that they are not only breaking the law, but also acting immorally and unfair by attacking one of its own members. Therefore, it is my legal right, and I will continue to record and share public meetings, as well as discuss my opinions and call for others to share their opinions on the content of these meetings. It is in the best interest of the town to reconsider its current course of action, similar to months back when their own lawyers suggested that they now proceed. We may discuss my submission in a moment, but I first must insist that I will continue to record this meeting and all future meetings. And I have notes here basically that says the meeting and council itself cannot function without discussing my agenda items. I demand to speak on these and other agenda items on the points of order as well. I tried to fix this in a settlement. We can discuss them up front, or an agreement that we do this later on after completion of the general business. And basically my community-related contributions can wait until another time. And that's basically what happened. I held on to the community-related activities to the follow-up meeting. Up to this point, we've spent approximately, I think, 15 minutes, I believe, exploring this so far. If the council had accepted my standing on a point of order, then it would probably take about 20 minutes to discuss it. Then we can put a pin in it, and the rest would be good for the rest of the night, and we can return to it later. I'm still waiting for the special meeting that was agreed upon unanimously to review my concerns that I called illegal and that I stood on a point of order for. At the time, I intended to discuss the following later on in the meeting. I must note that all of this was attempted to be dealt with through its regular channels, the right way, but it was not handled as one who would consider to be rational and proper, as they would expect. So we see the unwillingness to cooperate throughout the HR report, the occupational health and safety reports, all the orders, the access to information report, the recommendations, the summons, as well as the appeal documents, not to mention the audio recordings of the meetings in question. Not all items were read aloud, and the flow was not as planned due to the tension. but it goes to show my anticipation and planning. Imagine all the work that I've put into trying to fight for my rights, if I can put it into trying to help the town like I intended to. Imagine how different this community could be at this point if only people were agreeable and treated me and my family like humans. I did, however, and I must repeat, send an email highlighting my concerns and adding it to the agenda well ahead of the deadline for the meeting, and I had been discussing this in details with Municipal Affairs without solutions or any hope of remedy. I had hope, but based on the answers that were being given to me, it didn't provide any hope. In email, I drawled concern that there was supposed to be an ongoing HR investigation surrounding harassment from members of the public directed at me. I'd later been told that no investigation had begun, and no one got back to me about the status or helped me push this along, even after I inquired about it many times over email. As this investigation was supposed to be open and ongoing, I planned to ask the subjects not be that I'm not going to name here, not be present in the meeting to allow me to freely contribute without duress, and that any unruly or disruptive behavior from the gallery be the cause of removal from the meeting after a prompt verbal warning had been issued by the chairman or an objection by a councillor. It was proposed that it's been a year since my absence from council, and now that I'm back and I have some valid concerns that need to be attended to. I must make note that there is no particular method in place in the government of Newfoundland to allow for a councillor to be reappointed back to their seat. So basically, it's good luck, fight for yourself, see if you can figure it out, and you're on your own. Like I mentioned to the councillors during that sit-in meeting, or the mayors, the two mayors during that meeting, basically when this is all over and it's not them against me, it's going to be us against them, because they're going to be all on their own. The municipalities affairs, I should say, the municipal affairs people, they're an administrative arm of the town. They have no interest in helping councillors as humans. They want to help the best interests of the municipality as a long-living corporation. And any advice that the individuals can receive to help benefit them, there's no hope in doing so, because they're not supposed to give any legal advice. But for some reason, the town believes that they're getting advice from municipal affairs. And if they're perceiving this, then they're sorely wrong. And if they feel they're being led legally, then if they're not, then currently we're in the same boat and we're both not being advised properly, which means that at the end of all this, we'll be on our own if ever we have any individual councillor-related problems or any problems with how things go. Basically, I had notes that I had provided, such as what I'm reading here now, and I had all this entered into the supporting minutes. As you will clearly understand, this is my first meeting back, and I advised the town that we had to dedicate much of the time as a right to my reintegration, following being wrongfully kept from participation for a year. The items that I planned to discuss for submission were as follows. This reintegration will have a couple of key components that must be discussed in its entirety at council, including but not limited to motions to rescind the entire policies for remote attendance policy, recording policy, social media policy, policy as it pertains to councillors talking about public discussions and decisions before minutes are published a month later, and the VaxPass access policy or vaccination policies in general. All I've said so far was a representation of my email sent before my meeting back. There's been some changes to make it make more sense, but essentially this is the gist of it. The remainder are notes that I read for the minutes supporting document that were there for everyone to read. At the time of writing this, it was unknown if the recording policy had been rescinded on point of order at the beginning of the meeting. And little did I know the extent of the meeting that would culminate into an assault on a guest and a parade of horns from 30 anti-patriotic citizens seeing me off with police to my house at the town hall on April the 27th, 2023. Agreeing to allow recording would have been groundbreaking and fundamental to progress, as it would allude to willingness to resolve matters legally, logically, and transparently. The plan was, if the recording policy had not been rescinded, that the point of order may have to be taken again to discuss the other policies immediately rather than later on in the meeting. But things fell apart and there was no chance to discuss anything, and we still are yet to have an opportunity to discuss anything. At the time, I had anticipated that we may have police outside, and I suggested that we get the public interest conversation out of the way as a way to move on to the less interesting topics later, or after or schedule another meeting as a follow-up for such general things. Further to the points of order, these were my general submissions for the evening, and it was basically there to be added as supporting documents to the minutes. So essentially, I've taken care of all my important things so far. All the things that needed to have been discussed were essentially discussed. It was mainly the recording policy, and now it's the other policies that I would have taken an opportunity to discuss at a later point. But again, the recording policy was the policy that I stood on a point of order, because at that time I was breaking the rule, and standing on a point of order was a way to call out that the breaking the rule was illegal. I wanted to submit my disability accommodations request. Basically, it was the document that I originally wanted to read to the original mayor, but I was told to put it back in my pocket and he would make sure I was taken care of appropriately, but it didn't end up being that way. It's basically, the document is called Intro to Council, and I'll read that later, or if you look for it or Google it on my Facebook page, you can probably find it. It discusses implications, answers some questions, and it gives opportunity to ask some questions in the meeting, and for me to submit the document officially to the minutes. It's not really complicated what the content of the document is. Basically, it's just about respect and basic human resources or ethical judgment. It's the way that you would act and behave in a corporation. When I was asked during that meeting, when I had to sit in by the two mayors, do I think, or what kind of accommodation do I need? Well, I said I'd like to have it to make sure that we're not being aggressive to each other, and that we cut it off, and stop doing so if that were to happen. Basically, it was about, well, this is a council meeting. That kind of thing happens. What do you expect? Well, it's a business place first. You don't really expect that things to happen in business, and if you did, you need to nip it in the bud. But I don't think that was appreciated too well or understood in that degree well. But that's the way a business place is supposed to run. You need to have ethical judgment and be compassionate to other people. All of these things that we want to agree on. But it seems as though we don't understand that we're agreeing on the same thing, but we need to figure out what we don't agree on and fix that, not the things that we already agree on. I think we'll find that we agree on a lot of things and we don't actually realize that. I planned at the time to reaffirm that the council had allowed me to start a money engine, economic development board, to fund and process projects for the community. I've since been advised to get the information together and it would be reviewed. Now I need to ensure that I'm being respected and the people are being professional and responsive so that we can get things done effectively. I plan to call into motion that we repair the United Church parking lot. I've since been brought it up in a subsequent meeting and it was going to be looked at. So I'm going to ask what's happening to the parking lot in the next meeting. Bringing awareness to purchasing a Moby mat for Saltwater Beach Pond to cover up and stop the sand from blowing onto the campsites. It's since been brought up at a subsequent meeting and they're looking to see if it's suitable. Basically, it will cover the entire beach at the area that it's starting to blow. It's not slippery, and it'll keep everything from getting in your eyes and getting all over the campsites. I was going to inquire about the Heritage Committee and its progress, and I subsequently advised to get information about bylaws for heritage status for review. I haven't gotten around to that yet, but I'm going to be working on it very soon. I'd asked about the bridge and walkway for the kids who walk across a neighbor's lawn to cross town. This was later brought up in a subsequent meeting, and they're going to look at it. I'm going to check into it in the next meeting. The path has been made where they dug the ditch, and basically they just need a bridge to go across there at one point. There used to be one there, I understand, in the past, so it should be easy to put another one there now, and it'll stop kids from crossing the neighbor's lawn. Not that he's asked, but it's still a good thing to do. I planned and still plan to ask for an increase of hours, number of administrative staff, or to improve attention to details by administrative staff. I've been continuously asking, but yet to get a general update on the status of the harassment investigation I've initiated. So at this point, I've turned into actual details, the talking notes for my submission to council. Those are just mentioning the fact that they exist. What exactly does this mean? What are we going to do about it? Well, if we can't agree on all policies and procedures being mentioned, and be a motion to be rescinded wholesale without discussion. I plan to present all my thoughts and logic on each of these policies under each category for the evening, and I did in a subsequent meeting. I will read this as if I was going to read to council on April the 27th, 2023. I ask not so much that I must prove why you should not have these policies, but please use the words to explain why we should have these policies, what it accomplishes, and why we need it to be this way. There are many people waiting to report on the result of my motions to council to rescind these illegal policies and procedures. Please consider what we're doing and not simply reject it due to the ongoing disputes and who's asking you. It is better to rescind and review the documents for conditions that conflict with existing laws and provincial and federal laws before enacting them than to move forward knowing the town is still open to legal action against them, like my own action that I've brought in response to violations against my rights. The policies that exist are illegal. It's an overreach and a direct tool used to further alienate me from my elected position on council. I plead with all members to honestly consider my points for what they are, separate from the person delivering them. I'd like to deliver the entire presentation so you can know exactly what I'm asking before you discuss and respond. Otherwise, it'll take forever, bantering, and when all the points are concisely illustrated here. I have all the points. I like to discuss them in full for your informed reply. If you feel that you require me to make official reply to the motions and you want more time to think about it, we can delay the motions until we can reflect and review this document in its entirety, which by now you guys should have had plenty of time to review and see my reasons. The reasons for the motions to rescind the entire policies are as follows. Remote attendance policy. It presents discrimination and limitation instead of enabling public discord and political participation. It sets up roadblocks that seem aimed at creating conditions to get those restricted with the 3-month rule. The remote attendance policy specifically states that vaccination status does not qualify for this accommodation, and there's an obvious purpose for this clause given that remote work would separate the unvaccinated member physically and therefore eliminate any alleged danger this member would have allegedly be causing. It's counterintuitive to common sense, but it does make sense if being viewed as being created to prevent someone from specifically participating in their duly elected role. The limitations set in place to qualify remote attendance are in fact discriminatory. It also forces one into a moral conundrum where a small lie can be told in order to qualify for remote attendance. Basically, I could have said that I could not make the meetings for childcare issues. I have 3 kids after all, but it would be a lie, which doesn't solve any of our issues. I could say that I work up until the last minute before our 7:30 meetings, unable to physically attend, but then again, it would not be totally truthful. I could have lied, but lying isn't going to be able to solve anything. It only adds to more of the problems. Transparency, accountability, and morality will solve these problems, and that's it. The remote attendance policy should be rescinded in whole until council can replace it with something non-discriminatory. Recording policy. The recording policy of public meetings must be rescinded in its entirety and replaced with a policy that is created with all council members with legal advice as agreed upon unanimously when I was in office. The current recording policy for public council meetings stands in direct opposition with the law. I must remind the town that no policy can supersede the law. This is a public meeting. All that happens here is public unless we move into a privileged meeting where recording becomes questionable. Nothing is otherwise private. Nothing is proprietary or competitive requiring do not disclose agreements or warranting censorship. We cannot copyright, censor, or control the right to make public audio recordings of public meetings. To make this policy is to break the law. The Criminal Code of Canada, among other provincial and federal rulings, provide a precedence as required. The reason we had broadcast on Google Meeting was that legislation said that we must make meetings available to the public as it happens. To suggest that after it's public, that it moves into the private domain is simply incorrect. Every single person, both elected or citizen, is in a public assembly to discuss public matters with no reasonable right to expect privacy. It is a public forum, and again, attempting to restrict recording is against the law. We have a right to record any conversation one is involved in without breaking the law. If one was employed and recorded any conversation, then technically they could do so, but one could be terminated for any reason and probably would be terminated for this reason. This is the difference. The idea that we can't record or make those recordings public is also against the law. It's censorship. And I ask that we have this motion tied to the social media policy, which is also directly related to controlling and censoring public domain information. I plan to motion at that time that both policies be rescinded and replaced with unanimous council-approved alternatives. I plan to further a motion that we adopt the premise of Bill 495 and use the following words. Policy to authorize the recording of sound and images during the public sittings of a municipal council or the public meetings of a council or board. Explanatory notes. This policy reaffirms that municipal council sittings and community council meetings are legally open to the public. In addition, the policy specifies that a person may not be prevented from attending or sitting or meeting on the grounds that a person is not a resident in the territory of the municipality community. Lastly, the policy expressly authorizes that the recording of sound and images by a person attending a municipal council or meeting is permitted. Social media policy. Politicians of all walks in life have social media accounts. They often have differing opinions. This is laughable. To think that a municipal government believes that they can limit public discussion of public decisions and expressing differing or even concurring news to the public from an elected official's point of view is questionable. What is it that you're trying to accomplish by stopping free discussion of our deliberations and decisions? How do you expect to be held accountable in this day and age if not to have your decisions and examples of judgment displayed for all to see? What are we hiding? Why the need to not talk about our community activities and thoughts and how we can grow forward together? If not for social media, I would be wronged and held responsible for your actions, and no one would be any the wiser. The citizens would all think to themselves without any proof that I was fully responsible for the human resources investigation. I fought for my rights, and I won based on facts and records. Let's not fool ourselves. Councils talk about what goes on over the dinner table and with friends, and to limit this talk in policy only works for those following the made-up rules. I planned to motion to rescind this entire policy until it can be reviewed by legal counsel and vetted for purpose. I wanted to take a look at the policy as it pertains to councillors talking about public discussions and decisions before minutes are published a month later. I don't think I even needed to talk about this much. It is so wrong. Just the idea of not talking about public political matters until decisions are made and it's too late for citizens to talk about it is just ridiculous. Please, whoever made this policy, please defend it so we can hear the words and motivations for your decisions. This is the purpose of social media and the purpose of having your words recorded. If you can create these rules and policies and procedures, you need to stand up and defend them. Otherwise, they need to be repealed. I plan to motion that we prohibit censorship and control of councillors' opinions of expression, except where it's deemed offensive or illegal, as per existing laws and regulations. That would have been the motion that I had asked for. VaxPass access policy. I've heard rumblings that this policy does not exist. I've read the minutes, and the policy is on hold in case we need it again. It's discriminatory, and it is a large part of what got us into this situation today. I think that some of this policy had got repealed, but I want to make sure that all the policies dealing with vaccination has been repealed. As per Curtis Dahl, the other municipal lawyer firm in Newfoundland, alongside the recording policy and the remote attendance policy, the Municipalities Act were weaponized against me, and it prevented me from participation and resulted me in unfairly losing my seat. Also mixed up with the VaxPass policy, obviously. This policy should not be put on hold. It should be fully rescinded along with all other existing policies concerning any vaccination, and a motion to never restrict nominations due to how it could limit participation of an elected member. I have to make sure I make note here that during the last election, it was specified that no one unvaccinated should be part of any nomination process. I believe that is totally discriminatory and illegal to even suggest it. So in theory, the last election was done illegally and really should be recalled and have a new election. And if the people who got elected need to be re-elected again, then run for it and be re-elected again. Go for it. Fill your boots. As a council, it's time for us to admit that errors were made, and now we have the opportunity to make corrections. The Supreme Court of Newfoundland and Labrador has already affirmed that correction with its ruling. Let's continue with their lead. I demand an apology for the decisions and statements made by the council that affect me and cost the community $50,000, contrary to your own legal counsel's advice. Responsibility needs to be taken, and truth needs to be openly told. I have no responsibility for this $50,000 being spent except for me standing up for my rights. And it's pretty clear that the town was advised not to spend this money. And to kick the horse a little further, this could have ended way, way, way a long time ago with $10,000. But people's ego didn't let this happen. I also plan to motion that policies and procedures created for the first time after COVID pandemic begin, as it pertains to vaccination in any way, shape, or form, and as it pertains to limiting access to public information or participation of an individual in public meetings due to vaccination status would be repealed. I also plan to motion that remote attendance policy, recording policy, social media policy, and policy as it pertains to councillors talking about public discussions and decisions before minutes are published a month later, as well as VaxPass access, or whatever the name it currently exists, be rescinded in full until such point that legal counsel give a detailed report on the legal validity of the conditions proposed in those policies. Further to these crucial matters, we need to begin discussing the following tonight or at another meeting. Further discussion would have been the disability accommodation request. I wanted to submit my disability accommodation document, read the original disability letter, and discuss implications, answering questions, and submit documents to the minutes. The disability accommodation request for tolerance of neurodivergent state associated with symptoms and problems with stuttering, aphasia, and word avoidance, word selection, sensitive to noise disturbance, prone to bilateral social misunderstandings of intent because of symptoms of those conditions. I wanted to reaffirm to Council to allow me to start the Money Engine Economic Development Board to fund and process projects for the community. The town had recently been contacted by the 50 Plus Club for the same type of proposal that I had, looking for the town to ask for a Donee. This is a CRA status that a board can get to accept charitable funds. I had approached the town to do this for the community garden for the first project, but it was not well understood. This would have been an Economic Development Board type association, sort of like Cape Friels, that can process money. It's best to be done by the council itself to reduce the chance of fraud, but the funds tend to come with operational expenses, so this can be used to hire a qualified accountant who deals with charitable donations. When I tried to get contractors for Big Book Cemetery, I heard that they were being rejected by telling them that I was not associated with the town and not interested when they started to call the town for information. I want to make sure that I get communications going so that we can successfully have things move along cooperatively. Communication or lack of such is causing issues with the form of backlogs and the like. As noted previously, I've been waiting on my T4s for a month and asking in emails. And after I think about a week and a half ago, I was told I sent it in the mail. It never ended up in the mail. I got it in a PDF. It should have been given to me when I asked originally in PDF. When I asked for it in PDF, but it wasn't, and it just got delayed. There's other things, obviously, that's going on. They have subpoenas against them. They've had RCMP come out. They've had people from occupational health and safety come out in person to deliver orders because they're not responding to them in email either. It's just not running like a business. This is running like a convenience store, basically, as opposed to a corporation. And they expect me, who has worked in corporations over the past 20 years, to work in a certain way. And so do these corporations that I worked at. But when I try to act in this way within the policies and procedures and normal ways of doing things, they don't know how to do it, and they think that I'm the one that's causing problems because I like to stick by the rules. At the time, I decided not to call for 2 recent councillors to vacate their seats for a by-election. I was initially intent on asking that these previous by-election be called illegal because it required illegal stipulations of vaccination status and therefore discriminated against potential candidates. After some thought, considering the possibility of good faith extended during my first meeting back, I decided that I would not bring that to the table at this time unless I found out the council is not functional, and then I may need to call that out at a later point in time. It seems as though we're not too functional at this point in time, so I may need to ask for the council to stand down and let the election be fair without stipulation of vaccination, because who knows who was limited from becoming nominated because of vaccination status. We don't. And they could have got more votes than these people. We have no idea. I planned at the time to motion that we never restrict nominations or deny access to public matters due to how it can limit participation of an elected member or any member of the public based on vaccination status. I also planned that we call to do a motion to repair the United Church parking lot. We've used it for many years for snow clearing over the decades, and we've pushed a bank of snow towards the fence there, resulting in an inclination, indentation, and a large deep puddle, plus other new puddles that were created when they'd done the ditches there. This incline likely contains all the missing soil, or most of it anyway. Granted, ATVs had doing donuts there, but I suggest that it was more of an after effect, that the hole was there and they decided to do donuts as opposed to them making the donuts, because the dirt would otherwise be located, but it's not to be found. Recent ditching and clear up has also taken a lot of soil from the rear of the parking lot, and new damage has been done to the property. It's going to be sold in June, and I think it's responsible for us to put the property back to the way that it was before we damaged it. The dip is now quite large. The town has since gone back and fixed it a little bit, but the rear of the property is still damaged, as well as the hole and the divot is still present. I think the town should lead the role in this cleanup after being clearly responsible. The whole area should be leveled and put back to as it was, or even better. We damaged it, and it's been disrespectful over the years to see cars at funerals parked around the holes in the mud. And at the time, I planned to motion that we grade the United Church parking lot after being responsible for its damage and adding dirt back where needed and back to what was taken. But I didn't have to make that motion. They decided to go out and take a look at it. I'm going to ask what the status is at the next meeting. I also want to talk about the Heritage Committee in progress. A citizen has again contacted me about cemetery preservation. Now that I'm back, I want to pursue heritage interests for the community. Have we contacted Heritage Newfoundland to get a seminar on applying heritage bylaws to the town so we can avail the money through designation? All the cemeteries need designation, and we should identify other structures or locations needing protections. I've read minutes and Facebook posts about the Banting Plain replica, but wonder what's planned to be done now. This hadn't really been taken. This question hadn't really been asked because meetings haven't been very flexible to allow me to communicate. So not all these questions have been asked properly. But I also want to talk about the bridge and walkway for the kids who walk across the neighbor's lawn across town. I'd like to have Public Works look into what it would cost to install a simple bridge and a pathway between the apartments and the Wesley parking lot. After the ditching was done, a path has now been made. We should make it official and put a bridge there. The person who owns the property has kids crossing his lawn all the time. He may not mind that this is happening. He has not asked me to consider this idea, but I see kids going up and down that ditch all the time, and it's not like it's the only apartment in Canada that has ever had a public walkway near it. Seeing the need, and now that the land has been flattened, it seems intuitive to bridge the gap somehow. It would be good to put it on our interest boards so that when we find opportunity, we can do that for the community. The bridge and the path is a simple thing, but it goes a long way in bridging the community together and showing interest in social infrastructure. If we have no interests board, I plan to at the time motion that we create one and to look for ways to budget for the things on the board, like we've had for the snowblower, but not buy it right away. What happens if we lose track of the snowblower? We already approved of it. We need some board to put things on that we've approved of so we can budget for it, basically. Not necessarily to buy right away, but as pet projects when the time is right. I planned at the time to motion that we create a long-term interest board so that, again, if we were to not accomplish a task, future councils will have an idea what we had in mind so they can consider it as well. This will create community and continuity, I meant to say, between elections, foster a corporate vision, propel the community in a continuous path of collective will, not just on a whim. I also wanted to discuss increasing the hours and the number of administrative staff, or improve the attention to details by administrative staff. I've been communicating with administration to get basic information about policies and procedures, background on minutes and past meetings, looking for general information in my T4. This has not been readily available to me and not too forthcoming where realistic and where people would expect it to be so. It's been suggested by Municipal Affairs Director Christopher Stamp that our administration may be overworked and not able to get to these sort of tasks in a timely manner. I'd like to make a point that these are basic tasks requiring no oversight, and either I'm literally being ignored and sabotaged by deprivation of services, or the administration is simply overworked. I propose that we ask the administration to provide ideas and feedback on how they see their job improving and what steps were needed to improve this. We can take this advice and see if we need to increase hours, add more assistants, remove roadblocks, or offer training to improve effectiveness in the front office. There are no growth tools or prospects for administration position due to the short term of the councillors, no management above the administrator, and no planning and no accountability. With no planning, goals, or accountability, administration basically runs itself. It's not sustainable. Also, it is a disrespect that my emails are going ignored without a good college attempt to try to reply my honest questions with honest answers. How can I contribute if not respected in my role as a councillor? I plan to motion that unless communications are offensive or without authenticity, that administration will reply to all emails within a reasonable amount of time, considering timelines and context of the email. And if ever emails need to be ignored, that this list of emails be brought to the council for examination and assistance on how to deal with those emails could be offered. I also plan to look for an update for general information about the harassment investigation I initiated. I request that an investigation commence to address the harassment that I've been receiving online from a firefighter and 3 volunteers who fall under town harassment policies. And I've asked to see the harassment policy as it pertains to firefighters and volunteers, but I've yet to see a reply with the details I'm looking for. I wanted to ask the town at the time to please give me a general update as to the status of this investigation and what we need to do to move it along. At this point, I'll read my letter to council, and this will basically take care of all of the things I need to say. I think we've been about an hour now. I'll keep this as short as possible. I may look at you as I talk, but I'm not talking about you. I'm being general. My background is technology, customer service, sales, and idea creation. I'm very intuitive. I pay attention to small details, and I try to connect the dots. I love to help. People ask me why I bother to put certain things inside my head. I enjoy being aware and knowing. My strange behavior is because I'm a covert stutterer. Covert means that you can't really tell that I stutter most times, but I do, and it's mentally taxing for both me and the people around me. This makes me seem off when I'm overly confident due to my knack of premeditating the unknown, or when I'm stressed or excited, you'll hear me stutter. That doesn't indicate guilt or that I don't know what I'm talking about. On the surface, my on-the-fly words do not perfectly align with what's inside my head. I have phrases, sounds, tics, movements that help me get through words. You may interpret that some of my emotional state is of anger or sadness or what have you, but it's not a true representation of my intention. It's basically a mimicking of tone, for instance. Don't take my disability that I have as a weakness. I don't. I see it as a superpower. But there are some drawbacks which I've learned to cope with. I think the crap out of things in hopes of predicting outcomes before they happen. It's really challenging, but necessary, and it benefits me most often. It makes me seem rash when I don't need to think about things very long to give you an opinion. It's likely I've already considered your question before, and that's why my writings are so long. I think about many facets. I'm a strange cat, no doubt. People think there's something off about me. And I've said that I'm intuitive before, but I also have a tendency to take people literally when I trust them to be telling me the truth or not knowing that they're pulling my leg. Once I realize that you're being figurative, I can have fun with the rest of you, but that's the way my brain is wired. I don't see it properly that way. I consciously and subconsciously avoid some words. I call them stutter words. Medical professionals call it aphasia. People's names are a big problem for me. Your name may not come to my head immediately because I may be suppressing it based on the specific sound structure. This happens even for people that I know well. In conversation, this forces me to choose incorrect words sometimes. I ask for your forgiveness and grace as I correct myself if I'm mistaken and I misspeak, as the same grace that I would offer you. We are on a journey of discovery together. And if we shut people down or be rude to each other, we're not going to discover anything. We're just holding up the journey. It's what's happened for the past year. My disability makes it so that when I talk using more words than most people would for the same topics when I'm trying to be descriptive. I'm doing it now. I do it all the time. I overthink everything. The purpose of me telling you that I can primarily speak openly from my mind as opposed to from my paper is so that we can be constructive and that you will know where I'm coming from because of what I said. This is also because I have a symptom where I use as few words as possible due to the lack of words available at the moment and due to their challenge. I write much better than speaking off the cuff. This lack of word choice sometimes makes my sentences sharp because I'm trying to be concise, sometimes too sharp. Some people say blunt, but no, I'm trying to be nice. I'm trying to be concise, so I call it sharp. I really try to be a good person and be respectful to others, and I really want to hurt, and I wear my heart on my sleeve, especially when respect is given to me. I'm a little odd, I admit it, and you will see, as all my friends do, and grow to love me once you know me. It's been suggested by professionals that I am on the autism spectrum or some neurological diverse condition. Social cues and obligations are a challenge for me, but when they're open and honest and caring, I can have faith that things will work out. I just need a little bit of extra tolerance and kindness before you get frustrated. Yelling or being rude at me is not going to work. I can't speak or get in edgewise if people are talking offensively. It boils down to be unproductive, and then it would offend me and the purpose of me being on council, because if you don't want to listen to me, then what's the purpose of me being elected? I'm not trying to hurt anybody, and I would like to have the ability to take my words back if they're interpreted not as I intended. And the same goes for you. My condition means that I find it difficult to play verbal games and conform to the rules of verbal games, such as the Robert's Rule of Order. I do try to understand it, but doing all these different formal steps in an official meeting is a little too much. And I actually asked here, following the formal Robert's Rule of Order will make our meetings more courtroom style and less like a discussion. Very stifling and very difficult to be productive, I think. And if you take a look at some other towns' meetings, and you'll see online that it's very difficult to have these meetings happen, and we're expected to play along with those rules. I'd like to propose that we adopt an informal methods suggested within the Robert's Rule of Order. This way we can have normal discussions and call upon the mayor to be aware of these rules and enact these rules if things get out of hand when people are disrespectful to each other. If we can't function without the formal Robert's Rule of Order, then we must all learn them from inside and out, and learn the formal version as opposed to the informal version. I also like to call attention to the provisions that allows councillors to remove other councillors from office permanently if they're being disrespectful, non-productive, and disruptive on a continual basis. I hope that none of that happens here. We must all be professional, kind, and considerate to each other's opinions, and be willing to explore each other's ideas while not intentionally wasting time by filibustering or avoiding conversation. Filibustering is sort of what I'm doing here, but for the purpose of stopping developments. I'm sorry this is so long. I'll try to make myself as short as possible going forward once we understand the rules of engagement. I propose that we record our meetings so that any disrespect or inconsideration and all approach to subject matter will be public domain. If we could recognize this and agree, I'm sure we'll be very successful in leading the community. No motions required on these statements, and I look forward to working with you all. Grant. So this was the message I wanted to have read into the meetings, and I wanted to read to the mayor, but he had no interest in knowing what my accommodations were. This basically takes care of everything I needed to say. It talks about how I wanted to stand on a point of order and the content of the points of order and the reasons why I think that these things are illegal. Tomorrow there's a meeting, and now all people in the town council have an opportunity to hear my voice as opposed to read to the document if reading the document has been a challenge up to this point. I hope to see you guys on the other side when things that are illegal are rectified. Have yourself a great day. God bless. Take care.